Hi everyone, I'm attorney Aiden Durham with 180 Law Co. in Denver, Colorado, and you're watching All Up in Your Business. Intellectual property comes in many forms. A few of those most common forms are trademarks and copyrights. And it's pretty common for people to get the two mixed up. So in this episode of All Up in Your Business, we're going to talk about copyrights and trademarks, what they are, what's the difference, and are they ever the same? Occasionally, there will be some overlap between copyrights and trademarks, but for the most part, they're two very different things. Copyrights protect original works. Think of it like this. Copyrights apply to works of art and creativity. Things like paintings, books, videos, photos, sculptures. These are all creative and artistic works, and copyrights apply to them. A copyright gives the copyright holder the exclusive right to use, reproduce, sell, modify the work. Trademarks, on the other hand, protect words or symbols that are used to identify the source of a good or service and to distinguish it from the goods or services of a competitor. So trademarks are things like business names, business logos, service or product names, product packaging, those kinds of things. Really, anything that helps to define or identify a brand is considered a trademark. And a trademark gives the trademark owner exclusive right to use the trademark in connection with its goods or services. So putting this into the context of a business, copyrights would apply to things like photos, videos, websites, ebooks, marketing collateral, marketing material, worksheets or workbooks, whereas trademarks would apply to the business's name, logo, slogan, and things like that. Given this, it's pretty clear there's a distinct difference between copyrights and trademarks. But every once in a while, we'll have a little clash, worlds colliding, if you will, with copyrights and trademarks. And sometimes the same thing, the same one thing, can be protected by a copyright and a trademark. Think of the NBC chimes sound, that nee, 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 that sound that we all think of NBC when we hear those chimes. That sound, that chime sound, it's music. It's an original work of creativity or of art in that it's a musical creation, and so copyrights apply. But it's also used as a trademark by NBC. When the general public hears those chimes, we automatically think of NBC. That sound is used by NBC to tell the general public these are our services or our products, our TV shows, our programs, all of that. You're watching NBC. That's how you know you are, because you hear those chimes. So those chimes are protected both by copyrights, because it's a creative work, and it's also protected by trademarks because it's used by NBC as a trademark. And yes, I didn't mention this, but sounds can be trademarks as well. So can colors or even smells. You ever walk into a store and there's a very distinct scent when you walk into it? And if you walk into the same store in a different mall, it's that same scent. You start to recognize it when you're out and about. If you smell that scent, you associate it with that particular store. A lot of stores have trademarks over their scents that they pipe into the store to help customers associate that smell with their products or their services. So it's not just words or symbols, it can be sounds and smells as well. Logos are a common intersection of trademarks and copyrights. Logos will often contain some kind of drawing or design that is protectable by copyright. So as an example, Disney has various trademark registrations over the Mickey Mouse character. If Disney puts a picture of Mickey on a product, we see that product and we automatically associate it with Disney. We know when we see Mickey, that product or that thing is coming from Disney. So Mickey is a trademark of Disney in that sense. But Disney also has a copyright on the Mickey Mouse character, because the character itself of Mickey is a creative work that is also eligible for copyright protection. So because Mickey is a work of art, he's a copyright. But because Disney uses Mickey to indicate their brand, it's also a trademark. And this is somewhat common with logos for businesses. There will be some original artistic drawing in the logo, which aside from being a trademark is in itself a copyright as well. So the simplest way to think about it when we're trying to compare trademarks and copyrights are art. That's the way I like to think about it. Copyrights are art. If it's something creative or artistic, usually copyrights are going to apply, whereas trademarks are used by businesses to indicate the source of their products. Occasionally there can be an overlap, but for the most part, trademarks and copyrights are two very different things. That's all for this episode. If you've got trademark or copyright questions, feel free to shoot them down in the comments below. If you are looking for help with registering your copyright or your trademark, feel free to contact me. My phone number and email are below. I also encourage you to check out Brand Bombshell, which is my all-inclusive trademark registration package, which will take your brand from blah to bomb. Be sure to give a thumbs up and hit that like button so you don't miss any future episodes of All Up in Your Business. Thank you all so much for watching. I'm Aiden Durham, and I will see you next time.